Okay, this is part two of the interview, and if you missed part one, we covered why you need a will, what you need to bring when you meet with an attorney, what you should know ahead of time, and what an executor is.
Hello, and welcome to the Art of Money Mastery, brought to you by Harbour Diversified Financial Services. This show will simplify your life and guide you along your financial journey by making your personal finances easy to understand so you can make better decisions with your money.
So, Jose, can you explain to me what a self proving will is and why it's important?
That's a really good question. I have people tell me, "Oh, I prepared a will and I signed it and put it in an envelope." New Jersey requires that in order to a will to be valid, that an individual sign in front of a notary, someone who is like a court officer, and that there be witnesses. The reason for that is the person has to acknowledge, they have to sign twice saying, "I prepared this will on this date. I am the person." The witnesses sign a document, the same document. They say, "I observed him or her sign the will. No one forced them. They weren't coerced. They did it of their free will voluntarily." Because what you want to avoid is someone who is doing something against their will. Typically, you'll have children come to me and say, "My father signed this will, but we think that his third wife made it all up and it's not for real." So, how do you prove something like or unprove something that was done? So, what I do is when people come to witness, I take their identifications, I make copies of their identifications. You have to be over the age of 18 to prepare a will. So, what I did here, I printed out what would go in a will, the specific language that statutorily under New Jersey's statutes 3B colon 3-4 says making a will self-proved at the time of execution. That means at the time it's signed. And what it says here is, and you can insert whatever name, I, comma, the testator, sign my name to this instrument on this blank date of blank month of blank year, and being duly sworn, do hereby declare to the undersigned authority that I sign and execute this instrument as my last will, and that I sign it willingly, and in parentheses says, or willingly direct another to sign for me, that I execute it as my free and voluntary act for the purposes therein expressed, and that I am 18 years of age or older, of sound mind, and make no constraint or undue influence. And that's important in this area because so many individuals take advantage of the elderly population. Someone who might be in a nursing home or who's suffering from Alzheimer's, they go to somebody to prepare a will, or someone gets a will at Staples or prints something out, and they have somebody who might be a notary public come and sign that the person signed it, but it may not be valid because the person may not have been in their full mental capacity. And generally, when someone comes to me for either a will, a power of attorney, or a healthcare directive, I ask them or the sibling or the child, is your parent, do they have the capacity to go to a car dealership, sign a promissory note to buy a car? They say no. Then they cannot do a will or power of attorney because they just don't have the mental capacity. Now, if you sit down with the individuals and the wife is threatening the husband to do something, then he's not doing voluntarily. Or the child, "Dad, you better do this or else," then it's under coercion. So they have to be doing it under their free will, they have to be doing it voluntarily. Where it gets a little mixed up is where the husband and wife come together and they both say, "We're going to do the following," and we have this agreement. And they've already spoken about it before coming here, and they both have a unified front where they know that if one or the other dies, specific things will take effect. And sometimes they prepare a contract. I am doing this because when this happens, I expect my wife to do this. So there's a contract to back it up. But that is usually not the case. Usually they don't have a contract, but they have a unified front where if I die, My wife understands that she's going to take the house that's in our name together. She's going to take this, and I'm going to give my children from another marriage. And it gets hairy when there are children from another relationship, that the children are from a prior relationship. It gets very hairy, and that's where some of the litigation occurs.
So if they were to prepare their own will from like a kit or from the internet or something, there's just a lot of situations that they might not even think of.
If they do something, I would say, as I don't want to use the word stupid, but it would end up being pretty stupid to me, almost laughable, because they're trying to avoid paying a lawyer a simple fee in preparing a legal document which could have detrimental repercussions when they're dead. And then I've had individuals come to me with wills that make no sense. And I'll give you an example. Just 2 weeks ago, I had a younger woman, and I say younger, she's retired already, but she came to me because she went to a specialist attorney who was highly regarded to her from another person to prepare her estate plan. The attorney didn't put down in the will who the executor was. Didn't put it down. In the power of attorney, didn't put down who the attorney in fact would be. Made certain assumptions. And I started to laugh because she paid this attorney to do this and he didn't do it properly. So if she died right now and then, her will would make no sense. They would have to go to that attorney to see if he took notes, to see what it is, what she said, and then he would probably have to give his notes over to the court. So he opened himself up to malpractice because he did a horrific job. There are people in the community who prepare wills and not even attorneys. So there are people in the community who might be a tax preparer. And you find this common where someone who might prepare taxes or might be a preparer of some other document who might say, oh, I found I can do this will for you. And they don't know what they are doing. They go on the internet, they figure, and they know how to do taxes here and there, or they know how to prepare someone's immigration paperwork, and they think that they can go to the next level. And they are not attorneys. So they are practicing law without a license, which is a crime. And so I want to alert people to these type of things because it's different. If I prepared my own will, I can prepare my own will, but I can't prepare a will if I'm not an attorney for somebody else. It's illegal. It's a crime.
Okay. And in what circumstances should somebody have their will revised? Is there a certain time period that they should go back and check it over?
Anytime that you find that a situation has changed. So a basic example, you prepared your will 15 years ago, and perhaps one of your children have died and you had them as an executor, or your husband has died, or everyone who you named as an executor has passed away, or the person who you had as a trustee or as a custodian for your children have passed away, or you are no longer on speaking terms with someone who you named as the executor. Things change. Common, what I find is they're married today, 5 years from now. And I'll give you an example. I just did an estate plan for a young married couple, and I put in there, and they kind of found it strange that I put that a change in circumstances could be divorce. And they looked at me like I had three heads. And I said, you might love each other right now, but something might happen and you might get divorced. And I can't represent either one of you. However, this would be a significant change in circumstances where you might want to change, where the husband you love now and now you hate 5 years later, you don't want him in your will. You want him out of your will. And it made sense to them intellectually, but not at the heart level. And those are the things that when I speak to people and they look at me like I'm crazy, but I see it all the time. I did a will once for a married couple, and no sooner than 6 months passed by, the husband came to me and says to me, I need you to help me with my divorce. I said, what are you talking about? I just did your will. He said, no, she ran away with somebody else. And I was shocked. I said, I can't do it. I know you both. You need to go to another lawyer. Could I have done it? Yeah, I could have done it because I didn't talk to them about a divorce. I just prepared their will, but I didn't want to have any part of it. But things happen in life. People die, divorces happen, and there are always what we call in the law a change in circumstances. And that's a thing that you need to always have in the back of your mind, the change in circumstances. What are those triggering effects? It could be a domestic violence. Your husband or your wife can stab you, right? She can find somebody, stab you, and now you have her arrested. Is that a substantial change? Absolutely. Do you want her in charge of your will? No, you don't. She might be on drugs. Who knows what's happening? So these are things that could change a family and would change the reason why you would have someone either as your executor or someone that you would leave things to.
Okay, that wraps up this section on wills. Thank you, Jose.
Sure. Thank you very much for having me part of your program.
The content provided herein in writing, audio, or by video is for informational and educational purposes. The content is not intended as legal advice to the individuals reading, listening, and/or viewing any of the content herein. Each case is different, and as such, by accepting to view, listen, and/or view the content, no attorney-client relationship has been established between Jose Silva Jr. and his law office of Jose Silva Jr. Attorney at Law, LLC. Furthermore, the information here is a marketing tool and advertisement by Jose Silva Jr. Attorney at Law, LLC, and its employees, agents, and representatives. Should you have any questions regarding the content herein and wish a consultation with Jose Silva Jr., Attorney at Law, LLC, you must set an appointment for a consultation and pay the required consult fee. At that time, further and perhaps more specific information may be provided as it pertains specifically to individual cases.
Securities and insurance services offered through Royal Alliance Associates, Inc., member FINRA SIPC. Insurance services may also be offered through Harbour Master Diversified Financial Services, Inc. Advisory services offered through Investment Advisors Asset Management LLC, a registered investment advisor. Royal Alliance Associates, Inc. is not affiliated with either entity.